A ProPublica investigative report detailed how judges at an all-white Louisiana appellate court ignored petitions filed by wrongly convicted black prisoners, and they got away with it. The story began with a 2007 suicide note from a high-level court employee detailing how the judges instructed him to discard petitions from low-income prisoners who couldn't afford an attorney. Investigative journalist Anat Rubin penned the Exposé. It's called The Scandal That Never Happened. Her story outlines a 12-year cover-up that starts in 1994 and involves nearly 5,000 petitions from prisoners, petitions that were intentionally ignored. Anat joins us today. Thanks for joining me on The Griot, and thank you so much for all of your powerful and courageous reporting. Let's start with this suicide note that caused the domino effect that got us here.
Yeah, so in 2007, a court employee at the Fifth Circuit Court of Appeal, a high-level court employee, took his own life at the courthouse on a Monday morning. And in his suicide note, he wrote about a policy that had been in place at the courthouse since 1994, whereby the judges, instead of reviewing petitions by prisoners who could not afford an attorney themselves, Louisiana law says a 3-judge panel must review such petitions at an appellate court. They had decided years before that they were not going to read them anymore, and they assigned them to this high-level employee. He was in charge of central staff at the courthouse, and he developed a list of rulings, 15 rulings. 14 of them were denials, and one of them was a sort of technical grant. And he would just sort of glance at the petitions, read the petitions, and he would say to his secretary, "We're going to do a number 7 on this one," and she would type out a 2-sentence denial, sort of general language that was broad enough to fit a wide range of claims, and send it back to the prisoner.
Wow. Now, you reviewed thousands of documents from the petitions. The thing I always wonder as you examine each petition is if there are any connections across them, if there are any points of contact, any similarities between the cases or between the incarcerated people.
Yes. So a lot of the petitioners are making similar claims. The details of their cases vary widely, but the petitions that the prisoners are sending to the court are part of what's known as the post-conviction process. So the Sixth Amendment gives you a right to an attorney when you're being prosecuted. And in most states, including Louisiana, you have a right to an attorney for one initial appeal. Everything after that is called post-conviction. And that's where prisoners or people who have been convicted get to raise some very important constitutional claims. So one really big one is ineffective assistance of counsel. And it basically means that you're telling the court that you didn't have an effective defense attorney, and that he or she didn't raise the kinds of issues at your trial that might have proven your innocence. In Louisiana,
is that a tough thing to prove? You know, because I imagine everybody who's found guilty at some level feels like their lawyer could have done more, and I bet on some level every lawyer could have said this or done that, and sometimes it's strategic. Is that a hard argument to make?
It's a very hard argument to make. All of the arguments that you can make in post-conviction, which several defense attorneys I spoke with called the organic chemistry of law, all of the arguments in that process are very, very difficult to make, especially if you're not trained in the law. And yes, it's hard to prove that your defense attorney didn't do a good enough job. It's a really high bar, and in most cases, those claims get denied. But it's important to remember that this is happening in Louisiana, which is widely believed to have the worst public defender system in the country, where, in some Louisiana parishes, which is what Louisiana calls its counties, there are public defenders that have hundreds of active cases. Sometimes they perform mass plea deals for their clients. Many don't meet their clients until the day of the trial, even when there's a life sentence at stake. So those claims in Louisiana in particular have a much higher chance of having merit. And so even though it is a very difficult thing to prove, it's a very important claim in a state that doesn't really provide and has never really provided adequate defense.
What's been the response since ProPublica released the story?
One of the most interesting responses has been from other parts of the country, from lawyers in other parts of the country saying, hey, please take a look at what's happening in this county in Florida or in this region of Texas. It's very, very similar to what you reported on. And it sort of tells us, you know, we had a hunch in reporting the story that this courthouse, this appellate courthouse, did what a lot of courts do as a matter of course, but it had made it official and it got caught. And, you know, and we had a hunch that there is a pervasive attitude in the American system that people who have been convicted of a crime and have had their day in court and have been found guilty are in fact guilty. And when they petition the court to say otherwise, they're just trying to get out of paying the price. This is a remarkable assumption because decades of exonerations, I think some 3,500 and counting since the 1980s in the United States alone, have shown us that our state courts routinely make horrific mistakes. And yet we believe somehow that that's not the case. And we have made it almost impossible for people who have been convicted to say that something went wrong.
So I can sort of understand or imagine justice for people who have gotten a raw deal, people who have been railroaded, who got ineffective counsel. It's either a new trial or we release them. I would argue release them. As an abolitionist, I probably wouldn't want them there in the first place. I definitely wouldn't. But the question for me becomes, what do we do with the judges? You know, is there any chance that they will be held accountable? And if so, what does that look like?
Sort of part of what this story was about is that they were not held accountable. Many of the judges who had sort of hatched this scheme and oversaw it for more than 13 years are now dead. And the people who tried to expose them and to shine a light on the corruption that they were a part of failed. And I think that part of the lack of outrage in Louisiana around this issue, the fact that the Louisiana Judiciary Commission, which knew about this from this employee suicide note, investigated these judges and didn't discipline any of them, and in fact dropped the investigation 3.5 years later when one of the judges died. The fact that there was no discipline, there was no outrage, just shows us that this wasn't such an aberrant system that they were running, that in fact, this kind of indifference to prisoners and their claims is really pervasive, particularly in the Deep South.
Indeed. It's not a bug of the system. It's a feature. Anat, thank you so much for joining us. Everybody, the full article is available online at ProPublica.org.